Welcome. This is James Corbett of the Corbett Report with your EyeOpener report for BoilingFrogsPost.com. The passage of the Patriot Act in October 2001 is by now an all too familiar story. The American people, already suffering from the trauma of 9/11, were pushed into outright panic by the anthrax attacks, a series of anthrax-laced mailings that killed 5, injured 17, and shut down Congress for the first time in modern history. The act itself was introduced on a Tuesday and signed into law on Friday, before anyone had read, let alone understood, the sweeping changes it would introduce to American law. One of these changes were amendments to a little-known and little-used FBI instrument called National Security Letters. National Security Letters allow the FBI and other agencies to issue businesses and institutions with requests for private data on citizens, including financial transactions and communications records, regardless of whether or not they are even suspected of any crime, and to hold that data indefinitely. One of the most worrying aspects of the letters are their non-disclosure clause, which not only prohibits recipients from disclosing the contents of the letter, but even the fact that they have received a letter at all. The letters were first introduced as an amendment to the 1978 Right to Financial Privacy Act. Originally requiring issuing agencies to give advance notice of the request and allow the subject an opportunity to challenge it, the instrument was amended in 1986 to allow letters to be issued without advance notice in cases where the FBI had specific and articulable facts giving reason to believe that the customer or entity whose records are sought is a foreign power or an agent of a foreign power. At the time, compliance with letters was voluntary, and recipients frequently declined to disclose the information. In the 1980s and 1990s, amendments were passed compelling compliance and allowing the FBI to issue letters even when the subject of the request was not under direct investigation. With the passage of the Patriot Act, however, the scope of the program was expanded aggressively. Under the Act, the FBI was granted the power to issue national security letters against U.S. citizens, even if those citizens were not suspected of any criminal activity. For the first time, other agencies were also granted the ability to issue the letters, and, unlike other legal instruments for obtaining information like a warrant or subpoena, the letters require no judicial approval before being issued.
You'll never know if your records have been turned over to the FBI as part of one of these phishing expeditions. The business that turns over your records is barred from telling you ever, or telling the press that they've turned over your records, even if you're innocent, even if it were a phishing expedition. And so I think it's a very serious matter for American privacy, and the Inspector General of the United States indicated that the FBI keeps the records even if a person is cleared or a case is closed. So suppose you had a neighbor who didn't like you, who called an anonymous tip on you, and the tip was completely baseless. If the FBI issued a national security letter for your credit report, your bank records, your phone records, your internet transactions, the FBI would retain that information about you even if they realized that the tip was bogus.
Despite the incredible frequency with which the letters were issued after the Patriot Act, with the FBI alone averaging 50,000 letters per year between 2003 and 2006, it wasn't until 2004 that the program was challenged in the courts, with Judge Victor Marrero of the Southern District of New York finding that the national security letters violated both the First and Fourth Amendments. The case revolved around Nicholas Merrill, the owner of an internet service provider who was issued a national security letter by the FBI requesting 16 categories of information about certain customers, including email addresses, billing information, and a number of other pieces of data that remain classified to this day.
There was an FBI agent who gave me a letter. He was dressed in a trench coat. It wasn't raining that day. And it was a very kind of a surreal experience. You know, I read it, and when I got to the point where it said I could not tell anyone, I asked him, does that include my lawyers? And he kind of just shrugged his shoulders and said, I don't know, I'm just here to deliver this letter.
Refusing to comply with the letter, Merrill entered a years-long legal battle that included the FBI's dropping of its request for the information, but still insisting that he could not publicly speak about the letter or even identify himself as the recipient. It was not until August 2010 that the FBI partially lifted the gag order, allowing Merrill to be identified for the first time. Shortly thereafter, he appeared on the Boiling Frogs Post podcast with Sibel Edmonds and Peter B. Collins to discuss his ordeal.
Tell us about how you, as an operator, an internet service provider, received a national security letter demanding information about the activities of your clients.
Okay. Basically, how it began was I received a telephone call telling me that an FBI agent would be coming by my office with a letter. It seemed really vague. I wasn't even sure if it was a serious call or not. But soon enough, an agent did actually arrive. Now, I just want to say at this moment that actually I'm still mostly gagged. I can admit that I was the plaintiff in the case, and I can I can talk about specific, generic issues involved with it, but I can't talk about a lot of the specifics. And it goes down into like really fine-grained detail that I have to remember when I speak to you about it. If I mention to you the gender of the FBI agent that came, or if I mention to you which field office the agent came from, or if I mention to you the actual date that they came, et cetera, et cetera, et cetera. Hundreds of details are all considered classified still. They were all redacted in the court documents with black markers. So anything that was, marked out in the court documents is something that I can't talk about today.
And Nick, I'm reading here from an account in the New York Times that was published a month and a half ago, which says that you have a 6-page guide that was prepared for you by lawyers at the American Civil Liberties Union, and that you typically review that before you conduct an interview like this one, so that you don't run afoul of the rules. Now this is bizarre because you are not a suspect. You have not been charged with any crime or even a misdemeanor or infraction. Yet you, without any of those proceedings, have had your rights shaved, and you have to look over your shoulder virtually at all times to make sure that you don't step on a legal landmine.
True. In a way, it can kind of seem at times like the FBI is using its gag power to prevent public debate about this issue. There have been hundreds of thousands of these NSLs given out over the past few years. And so you can presume that there are at the minimum tens of thousands of people whose free speech is curtailed and who are not being able to participate in the public debate over national security letters, which has gone on in Congress once already in 2005, 2006, and now is coming up again for hopeful discussion, although I don't know if there's actually been any debate over it. So in any case, I think it's really a huge thing. And not only that, then you've got the hundreds of thousands of people whose information was taken without a warrant. And none of them know about it, of course, because the people who had to hand over that information are under gag orders. So there's quite a lot of people's constitutional rights being violated here. And in my case, it was ruled, the national security letters were ruled to be unconstitutional multiple times. But unfortunately, since we were never able to get the case all the way to the Supreme Court, that didn't become a binding ruling that prevented the FBI from continuing. In fact, they're still using the national security letters today.
In 2007, the results of an internal FBI audit of the National Security Letters program was made public. The audit only covered 10% of the Bureau's national security cases, yet still uncovered over 1,000 instances where the FBI broke their own regulations, including dozens of cases where they had requested information that they were not legally allowed to ask for. An Inspector General report released that March examined a sample of FBI case files and found that there were more national security letters issued than there were in the Bureau's reporting database. The report concluded that the FBI had likely grossly misled the public about how many such letters had been issued. In response, FBI Director Mueller admitted a pattern of abuse of authority within the Bureau that cast doubt on the ability of the FBI to guard the public trust. Also in 2007, it was revealed that the FBI have issued letters requesting financial records of American companies on behalf of the Defense Department and even the CIA, in direct contravention of its mandate to conduct investigations and operations exclusively overseas. The DoD letters do not have the same mandatory compliance restrictions as FBI letters, but when they were revealed in an ACLU lawsuit, it was discovered that the letters were coercive and often did not make it clear that compliance with the requests was voluntary. One of the most hardening things about the national security letters is that time and again, companies and institutions that have challenged the letters have succeeded in getting the FBI to back down. In Nicholas Merrill's case, the Bureau dropped its request and partially lifted the gag order, preventing him from speaking about it. In 2006, the FBI dropped a request for information regarding computer usage at a Connecticut library and withdrew a gag order on its recipients after being challenged in court. In 2008, the Electronic Frontier Foundation and the ACLU succeeded in getting the FBI to withdraw a request it had made for records pertaining to a user of the Internet Archive. Herein lies the hope inherent in so many of these inherently tyrannical abuses of government power, that when forced to defend their position in the light of public scrutiny, the tyrants will readily turn tail and run. But, as Sibel Edmonds goes on to point out in that Boiling Frogs Post interview with Merrill, what does it say about the hundreds of thousands of national security letter recipients who did nothing to challenge this practice? Surely nothing can be a more damning indictment of a society that once thought of itself as a beacon of liberty for the world, that fewer than 1 in 50,000 are willing to stand up and challenge the presumed authority of an agency and a process that is clearly and admittedly out of control. So in this microcosm of the national security letter, we can see the macrocosm of the police-state control grid as a whole. If it is true that for evil to triumph, good men and women must do nothing, then all it takes to defeat that evil is for good men and women to simply say no and hold their ground. This video is brought to you by the subscribers of BoilingFrogsPost.com. For more information on this and other topics, please go to BoilingFrogsPost.com. For more information and commentary from James Corbett, please go to CorbettReport.com.